right. So we're doing today CRW 2601. CRW 2601. We're doing our final year on criminology and CRW selected topics of criminal law. So we can move now to learning unit 1. Curriculum transformation. Learning outcomes. When you have worked through this learning unit, you should be able to demonstrate your understanding of how the Constitution accepts customary law as a source of law, the advantages and disadvantages of the Traditional Courts Bill, what is meant by living law, the general elements of an offense, the introduction. One of the most imperative in higher education in South Africa is that the curriculum should reflect the views and values of our African heritage. We know how colonialism changed the lives of indigenous people around the globe, from Africa to India, as well as in many other places around the globe. The question which we now have to face is, how do we include our African heritage in the current dealings with law, and more especially for this module, how will it impact on criminal law? Fortunately for us, this question has already been addressed by our legislature and parliament. The Constitution. The starting point in this discussion will undoubtedly the Constitution Section 211 and 212 recognize the role of traditional leaders. Customary law is explicitly recognized by Section 211, and the Section 211 subsection 3 states that the court should apply the customary law where applicable. This means that Roman Dutch law and customary law are both sources of law in South Africa, and both are commonly applied. Even though it is not highly publicized, customary law is practiced on a daily basis in many rural areas. The Traditional Courts Bill. In 2008, the legislature introduced the Traditional Courts Bill. The purpose of this bill was to formalize the role of traditional courts play in South Africa. This bill was heavily criticized because it would undermine the rights of rural people, and women would be prejudiced the most. As a result, it was withdrawn and the bill was reworked. In 2012, it was reintroduced, but was met with the same criticism as the 2008 version. In 2017, the bill was introduced for the third time. It was heavily reworked to address the concerns of the past and was also carefully crafted to conform to the requirements of the Constitution. The role of women as litigants was strengthened, and the traditional courts were required to promote participation of women as parties and members in the court. One of the more controversial aspects of the 27 version of the bill is that a person may opt out of the traditional court system and choose to go to a regular court instead. For some, this section is tantamount to showing extreme disrespect of the traditional court. Even with this concern, it is still part of the current bill. For our purposes, it is important to consider the jurisdiction of the traditional courts. If this bill should finally be enacted, Section 4, subsection 2, B1 mentions that the traditional court may not hear and determine a dispute which is being investigated by the South African Police Service. This has the effect that traditional court will not have any criminal jurisdiction over any matter that is investigated by police. The exception is, of course, if the victim of crime chooses not to report the matter to the police but reverts to the traditional court instead. This is very unsatisfactory arrangement indeed for any victim of crime. The conclusion is that as the bill now stands, it seems that traditional courts will have no or very limited criminal jurisdiction in South Africa. As a result, it is very difficult to incorporate customary law into a module such as this. Having said that, there will still be an attempt to illustrate our African heritage where possible. It should also be noted that the traditional court is still a bill of parliament. It has not been enacted and has, as it now stands, no legal force whatsoever. The bill could be substantially changed in future, and it might even be possible that certain criminal matters could be placed under the jurisdiction of traditional courts. This is, however, highly unlikely as states tend to keep criminal jurisdiction within the exclusive domain of their power and are often unwilling to devolve such powers to other authorities. Living law. Customary law is often referred to as living law, and by this the message is conveyed that it is the law of the people, which changes as society changes. It is never static and conforms to the specific ethnic group that practices it. South Africa is rich in ethnic diversity, as can be seen in its 11 official languages. Each ethnic group has its own body of law that regulates it. When discussing customary law, it is impossible to address the atrocities of each ethnic group law. Some ethnic groups steer clear of the notion of crimes and criminal law and prefer to deal with wrongs in a restorative fashion. Other groups welcome the study of criminal law as it identifies wrongs that should be punished in order to have a more ordered society. In this module, it would not be useful to discuss differences in South African ethnic legal systems. The best that can be hoped for is to identify commonalities in ethnic diversity and give attention to those principles. Revision of general elements of an offense. Introduction. When studying criminal law in South Africa, it is common practice to divide the subject into two main areas: the general elements of an offense, the requirements of the specific crimes. There is a very good reason for this, as a study of specific crimes builds upon the principles learned in the study of the general elements of an offense. The general elements of an offense were discussed in the module CRW 1501. We assume that you have a thorough knowledge of general elements of an offense. The following pages will simply act as a refresher to review the main areas which were discussed in that module. The general elements of an offense. Although academics differ on the detail of how a crime should be divided into its elements, we can accept for the purpose of this study that a crime has four elements, namely legality, conduct, unlawfulness, and culpability. In other words, before a perpetrator can be convicted of a crime, his actions should comply with all four elements of a crime. If the perpetrator's action falls short of even a single element of the crime, then he did not commit the crime. His actions may be morally unacceptable, but if his actions do not comply with the elements of a crime, he cannot be held legally accountable for his actions. When we say that an offense, or another word, crime, consists of these four elements, then it means that all offenses share these common elements. The study of the general elements of an offense, therefore, looks at the common traits that can be found with all crimes. Having said that, it is common knowledge that crimes are different in many ways. For example, murder is a totally different crime from theft. How do we account for the differences in these crimes? The answer to this question is found in a study of specific crimes. This is what this module aims to do. So we know that for human actions to be considered as crime, they have to comply with the general elements of an offense, which applies to all crimes, as well as the specific requirements for the particular crime. In this module, you will notice that we often refer back to the general elements of an offense when discussing specific crimes, because the general elements are an integral part of what makes a certain conduct a crime. Let's look at a brief overview of the general elements of an offense. Legality. Legality is simple, means the certain conduct should be regarded as a crime before someone can be held liable. In other words, the general population should be aware of what conduct will be punishable. Just think how chaotic our society would be if the police or other authorities had the power to punish someone for any kind of conduct. One day, the police could arrest people for walking in the streets instead of on the pavement, and then arrest someone the next day for wearing green shoes. It is obviously that a body of rules should exist to limit any authority, such as that of the police, from acting in a random way. It is important that a body of rules should exist so that people in a society may know what is acceptable and what kind of conduct will carry a penalty. Another important aspect of legality is that the legal rules should exist before someone is punished for it. If John is arrested for walking in the street and not on the pavement, and the legislature makes a new law prohibiting walking on the street only 2 weeks later, our sense of fairness would protest if John is punished for this action. At this time of walking in the street, John did not know that his conduct would be punishable, and therefore it is unfair to hold him liable for it. In legal terms, it is said that laws should not be made retrospectively. In a criminal law, all crimes are either contained in the criminal law or in statutory law. This means that when we are dealing with crimes, the elements of legality will be satisfied as the law already contains all actions which are deemed to be punishable. Conduct. The conduct element is arguably the most important element of a crime. The perpetrator should perform an act which is prohibited in law. This conduct can take the form of a positive act, or it can also be an omission. A positive act is the most common form of conduct where the perpetrator causes his attention on performing a certain act and does what he was thinking about. An omission takes place where the perpetrator does not act in circumstances where there is a legal duty on him to act positively. In certain circumstances, the law will place a burden on some people to perform a positive act. If they fail to do this, it will amount to a crime. You will learn about an example You will learn about the example of this in this module when you study corruption. When when a person in a position of authority in a company learns about corruption activities that are taking place in a company, he will commit a crime if he fails to report this to the authorities. Remember though, that a person can only be held liable for an omission if there was a legal duty on him to act positively. When a person acts through another object, the law regards this as an act. For example, if Joe incites his dog to attack Sue, then Joe can be convicted of assault even though he did not touch Sue. The dog attack will be imputed to Joe because he is the main agent behind the attack. Unlawfulness. In our law, the term unlawfulness means conduct which is unjustified. It does not mean against the law. The reason for this is that a person's conduct will be against the law if all elements of a crime have been complied with. Unlawfulness has a much narrower meaning than against the law. The main criteria to determine unlawfulness is the Bonner-Morse, which is also known as the legal conviction of society. The question that will be posed to determine unlawfulness: would society condone this action? If the answer is the affirmative, then the conduct is not unlawful, i.e., it is lawful and the perpetrator will go free. A second aspect to unlawfulness determines whether there is any ground of justification which the perpetrator can rely on. In other words, did the perpetrator perhaps defend himself against a prior attack? If so, he can rely on a ground of justification, and in such a case the perpetrator will go free and he did not commit any crime. There are quite a number of grounds of justification in our law, of which the most common are private defense and necessity. Others include obedience to lawful orders, consent, and official capacity. Note that the list of grounds of justification is not exhaustive. It is possible that the new grounds of justification could be created if necessary. Culpability. When a person performs an act, he does so with a certain state of mind. The element of culpability tries to determine what the state of mind was, and because we are essentially determining what a specific perpetrator was thinking, we can understand that this is a subjective element. Culpability deals with the specific state of mind of a specific perpetrator. The law regards two states of mind blameworthy, namely intention and negligence. A person will act with intention when he directs his will towards commission of the offense, and when he knows that his actions are unlawful. These two sub-requirements of intention are commonly referred to as direct of will and knowledge of unlawfulness. The crimes that you will study in the following module all require intention, with the single exception of culpable homicide, which requires negligence. A person acts negligently when when his conduct is contrary to what a reasonable person would have done in a similar circumstances. For example, if a person drives down the road at 120 kilometers per hour in a 60 kilometers per hour zone and he passes a park where small children are playing, he will be negligent if he should kill a child and runs in front of the car. The reason for this is that this perpetrator acted contrary to what a reasonable person would have done. A reasonable person would have known that a real risk exists when driving at such excessive speed past a park where children are playing, that a child might be hurt or killed. Please note that intention and negligence are mutually exclusive. The one excludes the other. It is impossible to have intention and negligence simultaneously. The perpetrator either acts with intention or with negligence, but never with both at the same time. Activity. Which sources of law are recognized by the South African Constitution? Do you think Traditional Courts Bill is a positive step, or it is discriminating against the very people it intends to assist? Explain briefly. Explain the general elements of an offense in your own words. Okay, I think we are done now with the first study of the day. Today is the 11th of January 2025. Danko, thank you.